Everyone may be seated. We are now recording in the case entitled "The State of Ohio versus Ruth R. Miller." It's case number 2025 CR 090285. And we are here today for a final pretrial conference. Ruth Miller is seated at council table, and she is seated there along with her attorneys in this matter, Ian Friedman and Madeline Grant. The state of Ohio is represented by Assistant Prosecuting Attorney Fred Scott. And Ruth, we are here, I always schedule a final pretrial to meet with lawyers, to find out from them as to what has been taking place, and most importantly, how they anticipate that we are going to be proceeding in these matters. Ruth, they tell me that this is a case in which I should anticipate that this is going to be going in the way of a bench trial, which would mean I would be deciding the outcome as opposed to a jury. Right to a jury trial is a fundamental constitutional right that everyone would have in a felony case. So to get to that point of having a bench trial, it would require that we have a dialogue about waiving of that constitutional right. But before I launch into that discussion about right and waiving that right, I think it's best that I hear from the lawyers in this case to make sure I'm on the right page, and if I am, then we'll have that discussion. Ruth, I'm going to start with your side here first, and then I'll hear from this side of the room next as to what their expectations are. So Ian and Madeline, whoever wishes to speak.
Thank you, Your Honor. Good afternoon. Your Honor, you are correct. There would be a waiver today making this proceeding a bench trial in response to what has been stipulated to by the parties and is being admitted to you for your consideration. That is a list of 5 exhibits which the state is providing to you. Exhibit 1, mostly made up of that discovery, police reports and the like. And then exhibits 2 through 4 are the mental status evaluations. The first by District 9, that which you called for and was performed by Dr. Rinko, H-R-I-N-K-O. The report from Dr. Hatters, H-A-T-T-E-R-S hyphen Friedman, F-R-I-E-D-M-A-N. There is no relation, just to be clear. And then third, the mental health evaluation by the expert, Dr. Merritt, M-A-R-E-T-T, that was engaged by the state of Ohio. Those 3 reports all concluded and opined that Ruth Miller was not guilty by reason of insanity at the time of the conduct in this case and could not appreciate the wrongfulness of her conduct at that time. Parties agreed to and stipulate to the authenticity of the reports, the content therein, and to the findings. And so we bring that to your attention along with Exhibit 5, which is a zip drive containing statements that were made by Ruth Miller to Captain Fisher at the date in question, the date of the incident. It is our expectation as we go forward. Attorney Grant and I, at this point, are not calling certain witnesses for the bench trial, as we'll be relying upon your evaluation of the records that are being submitted to you, that if you accept the stipulation by the parties that the hearing of Ruth Miller was in fact, and just for brevity's sake, NGRI at the time, we would then move on to placement hearing at the time that Your Honor sets. So for all those reasons and for the findings that are contained in it, it was unanimous. There were no experts that opined differently because of that, the defense at this point is going to rely upon presentation-wise for the bench trial to that which is being submitted to you only. Thank you.
Thank you. Right, on behalf of the state.
Yes, Your Honor, Mr. Friedman did accurately depict our discussions. As you know, I've taken over the case for Mr. Steyer, who's going to be taking the bench across the hall in a couple days. I did put together a list of the police reports that I believe, most of the supplements that I believe describe the conduct so that you have information to make a determination that Ms. Miller did indeed commit the acts with which she's accused. And that's about 42 pages. And then there are 3 mental status evaluations. One obviously conducted by the court's psychiatrist, one then conducted by the defense psychiatrist, and then one conducted by a psychiatrist hired by the state of Ohio. Given the findings, as all 3 opined for various reasons, that Ms. Miller did not appreciate the wrongfulness of her conduct and was suffering from a severe mental illness or defect at the time of the offense. Given that, we have decided to submit this case to you for a non-jury trial, for you to review those matters and make an appropriate finding. And as he indicated, I've also included a zip drive containing the 2 interviews that Ms. Miller gave to Captain Fisher, the Tuscarawas County Sheriff's Department. So we are in agreement that there's a stipulation as to the authenticity and the admissibility of all these documents, I believe. And with that stipulation, we would not plan on submitting any other evidence next week or at whatever the trial date is. And we would just rest and wait for your conclusion.
Okay. All right, with that recitation then, Ruth, let me tell you what I believe, what I anticipate as far as how this case will proceed, and then I'll have that discussion with you, so that you know so you know how this matter is proceeding before you would waive any type of fundamental right. So what they've said to me is that, and what I think they are anticipating, is that there are 5 exhibits that they want me to consider. A couple of police reports and 3 expert reports. One that I ordered, which I've already seen. One that you had acquired through your counsel that I have not read. And the report that was generated by the state that I have not read. And I don't know how long they are, but I know they're going to take a little bit of time to review, along with a lengthy police report. My expectation is that they want me to consider those, read through those. I'm not going to be admitting them. Today is not the trial, but they're essentially giving them to me as a preview to look at. We would then come back next week to conduct what I've referred to as a bench trial. It is a non-jury trial, as the state has called it. Bottom line is, Ruth, there wouldn't be 12 people sitting in those chairs over there listening to evidence, listening to argument of counsel. It would be decided by me, and it would be decided based upon those 5 exhibits that I'm going to be receiving from the attorneys in this case. Ruth, you have an absolute right to have this matter decided by 12 citizens. The way that would work is that the room would be filled up about 50 to 75 people. And from those people, we would pick 12 that would sit over there in those chairs. And your attorney and the state's counsel would have the opportunity to inquire of those 12 people to find out whether they can be fair and impartial. And ultimately, after going through however many people we have here, the court and counsel settle upon 12. And those 12 would listen, and at the end of the case, they would be given the opportunity to deliberate or go off in a separate room and consider what they've heard. It would require all 12 of those individuals to be unanimous in their opinion that you were guilty before you could be found guilty in this case. That's an absolute right that you have. But we all have constitutional rights, and we all can waive those constitutional rights. The key is that we make that decision knowingly, intelligently, and voluntarily. Ruth, have you had an opportunity to discuss this matter? And I'm not interested in what was said. I'm just interested in knowing, did you have a full and fair opportunity to discuss that matter with your attorneys? I just need you to answer out loud. Okay. And you feel as if all of your questions and any concerns you may have with that right were answered by your attorneys? Okay. And you have confidence in their representation in any advice that they have given to you? Okay. Do you understand that, Ruth, that I'm asking you at this time if it is your intention to give up that right to having the matter decided by that jury or 12 individuals? Okay. And is it your intention to waive that right to have the case decided by a jury? Okay. Then, Ruth, I'm going to provide you with this form. And it's just reflecting what we have discussed here today, but I want you to take a moment, if you need to discuss the matter further with your attorney, to make sure that you have all your questions answered. The record should reflect then that the waiver of right to jury was signed by Ruth Miller here in the court, in which she indicates, I, Ruth Miller, defendant in the above referenced case hereby voluntarily waive my constitutional right to a trial by jury on the felony criminal charges contained in the indictment in this case, and consent to the trial of the criminal charges to Judge Michael J. Ernest, and I have not been forced or in any way coerced in the exercise of this waiver. And then, just to confirm, Ruth, you signed this document, correct? Yes. Then I'm going to accept that waiver of the right to trial by jury. And we already have a date that is set for next Tuesday. I apologize, I don't have it in front of me.
It's March 3rd at 10.
Okay, March 3rd at 10, set for a status conference. And that's the date we were going to utilize now for the bench trial, correct?
Correct, Your Honor.
All right. Then what will happen is, Brett, if you could provide me with the exhibits that you want me to consider for the ruling of the bench trial.
Your Honor, if I may inquire, so we're to expect that day a verdict from you
Exactly.
on that day, so
Absolutely.
Tuesday.
That is the reason that rush through this and get a full understanding of what's in here, because like I said at the outset, I have not seen what your expert has generated or what the state of Ohio has generated in this case. I heard what they said, so it's not going to be a surprise as far as their conclusion. I heard Attorney Friedman, so I'm anticipating where this is going, but I want to actually read it. Understood? Do you have any questions for me, Ruth? Okay. Counsel, any questions?
No, thank you for your clarity.
Okay. Brett?
No, Your Honor.
All right, then we will see everyone back here in approximately a week for that bench trial.
Very good. Thank you, Your Honor.
I'm gonna let Brad do his bill.
All right. Thank you, sir. Tuesday.
March 3rd.
March 3rd, Tuesday, March 3rd. That's the verdict, yeah, that's the verdict. March 3rd? Yeah, 10 o'clock, so March 3rd. Correct. He's gonna, yeah, he's going to issue his verdict.